Joshua Gerald was found guilty of second-degree murder of Mr. Leroy Scott. He appealed this decision, arguing that his Sixth Amendment right was violated because the jury did not represent a fair cross-section of his community. He also argued the prosecutor conducted misconduct. Let's get it started.
Good morning. Please be seated. Welcome to Division 3. We have two cases on this morning's calendar, State versus Graham and Hester, no, excuse me, I'm reading the names of the attorneys, and State versus Lauderdale. The first case is State versus, and I'm reading the attorney's name, State versus Gerald. I'm getting off to a good start. Welcome. So instead of reading the cases off, I'll introduce the panel. To my right is Judge Tracy Staub from Spokane. To my left is Judge John Cooney from Spokane. We welcome counsel for the appellant to come forward. I understand we have a Rule 9 intern here arguing the case.
Yes, Your Honors. Good morning. My name is Steve Graham, and today it will be Megan Casey, Rule 9, presenting argument for the appellant.
Thank you, Ms. Casey. Welcome. And so I'll explain how our clock works. Go ahead, put your stuff down and I'll explain how our clock works. So you'll want to begin by letting us know how much time you want for rebuttal. You'll see that you've got your clock and there's also some green light, yellow light, red light. When you're in your rebuttal, the green light will move to yellow and your clock will continue to go down. Once you're done with your time, the red light goes on. So if the red light goes on, all your time is up. So watch your light for you. I'll try to remind you if you get into your rebuttal time, but you'll also want to look at the clock yourself. So please proceed and let us know how much time you would like for rebuttal.
Good morning. May it please the court. I would like to reserve 3 minutes for rebuttal.
Thank you. Please proceed.
As Mr. Graham introduced me, my name is Megan Casey and I'm a Rule 9. I'm here for the defendant appellate, Joshua Gerald. Mr. Gerald asked this court to review this case as an abuse of discretion for the judge's comments, and we would like this court to take the initiative to address the racial disparity found in Washington juries as our state Supreme Court requested in their 2020 letter. In the alternative, we would ask the court to review this case to know sufficient evidence. For a little bit of background in this case, Mr. Gerald was charged with murder in the first degree on May 4th, 2020. Both co-defendants in this case and the victim, Mr. Scott, were Black African Americans. Because of this, defense counsel raised the possible lack of jury diversity on February 12th, 2021. In response, the Chief Criminal Superior Court Judge in Kittitas County stated, and I quote, "It's likely there'll be no one of color on this jury." That's kind of the population of this county. In response to this, Mr. Graham went to the county clerk to see if the process of the jury selection and the jury summons was on file as required by statute RCW 23665. It was not on file. The county clerk, in fact, had no idea what defense counsel was talking about. Then later in the morning hearing before jury selection, the lack of diversity of jury was brought up again. The Superior Court judge, as cited in the state's motion, recognized the fact that we were starting from behind in regards to Joshua Gerald's race. And then the prosecutor themselves stated in that same hearing, from a personal standpoint, I get it. I don't have a solution. And then further during jury selection, a jury member themselves discuss the demographics and the lack of diversity.
Ms. Casey, I'm wondering what kind of constitutional claim, is this a fair cross-section claim? And if so, can you go through the Duren factors for that?
Yes, Your Honor. So this is a fair cross-section challenge. Under Duren, there needs to be a distinctive group found in the community that was unreasonably underrepresented, not only with their own jury within that jury, but then the jury than yours generally, compared to the number of such persons in that community. And then
How would you define the community?
in this case, we defined the community as Kittitas County since we were in Superior Court. And then the third prong is that this underrepresentation is due to the systemic exclusion of that specific group in the jury selection process. So during themselves, they stated African Americans were a distinct group. However, because the judge specifically stated that there would be no people of color, we used that group because that was the demographic that the judge himself laid out for us.
So just hold on for a second. Are you concerned about the exclusion of Black members from the veneer, or are you concerned about people of color from the veneer? What's your exclusion group that you think is excluded?
Well, Your Honor, so there was no statistical data available for Kittitas County and the jury summons and selection process as a whole. So normally we would be looking at specifically the exclusion of Black people from the jury, but because there was no data available, we moved to the people of color as a whole because that was the demographic that the judge specifically stated.
Is there evidence in the record of, so I think that raises two issues. One is, do the case law recognize people of color as a distinct group demographic, or are we talking, is it more granular than that? And what are the demographics for Kittitas County with respect to people of color? What would one expect to find on a cross-section claim?
So under Duren, it was specifically African Americans, and I would say case law as a whole would look at that broken down demographic because there was just no data in general about it. There is, the census data is generally, as we all know, broken down individually. Like for Latinos, for example, they are generally broken down. However, the Superior Court judge, that's the person who lives in the community and sees the community and works with the community every single day. And because he specifically stated there was no people of color, that raised our concern that, hey, maybe there's something going on and it's further just than that one group of African Americans. We're looking at a much bigger concern as people of color in general are being excluded.
So, and so because of that concern, you then requested this information, is that correct?
Yes, Your Honor, and that's when Mr. Graham went to the county clerk and the process was not on file. In the next hearing, the state themselves offered as, hey, we could just call the court administrator and they should have it on file. That's not the person under the statute who should have access to it. Neither of the Superior Court judges knew where the process could be on file. At that point, we felt as the defense team that if the process itself isn't on file, they're probably not going to keep each individual jury makeup and breakdown on file because that's a bigger data selection. Because of that, we looked at just general possible data open to the public. We found that Washington State does do surveys periodically of the summons process. In all three of those surveys, Kittitas County either didn't participate or it was too small of a sample size for them to be protect the identity of each of the jury members. So there just was no data available aside from the census data itself.
From the census data?
Yes.
So we don't have a breakdown in Kittitas County, or we do?
Have the breakdown, I apologize. So there is a little over 16% of people of color in Kittitas County as a whole.
Okay, and then what about African Americans?
African Americans, it was 1.5%.
Okay.
But like I said before, the clerk itself didn't have access, didn't have it on file. We moved towards that census data. And because of that, that's why we have that fair cross-section concern. Not only do we have both Superior Court judges who are in charge of making sure that this data is randomly checked on and make sure everything is up to date. Neither one of them knew where we could find that data. There was no data just given to the state as a whole. And so that.
How is this case different than Rivers?
Well, Your Honor, first of all, Rivers did have the data in general, but that was an observation case, so they noticed that there wasn't any Black people on the jury. Here we have a judge specifically stating that there will be no people of color. And then he states that it's due to the population of the county, which 16%, no people of color, that's large enough that people should be coming.
So are you saying that the judge's comment? I guess I'm not clear. Was his comment just, it was
Judge Hooper,
Sparks?
I think.
Judge Spark.
It was Judge
Initially,
Sparks.
okay.
Initially.
Yeah. So was Judge Sparks's comment just an observation from his experience, or are you interpreting it as something else?
I can't speak to his thought process behind it. What I would say is it's probably based on his experience and what he's seen. Later on in the record, he does explain that he hasn't seen very many people of color come to it. So I would assume it's just based on observations.
And then Judge Hooper, was it Judge Hooper that later explained that she had a different experience? Is that correct?
Judge Hooper later said that she recognizes that we're starting behind in regards to Joshua Gerald and his complexion. So I would say that's more in line with Judge Sparks's observations as
So-
well.
Rivers has three components, and I think Rivers says Washington State is doing a poor job getting more diverse juries, and there's a lot of explanations for that. Some of it is due to low pay, travel, all sorts of reasons why people aren't showing up for jury service. But that didn't result in a reversal in Rivers because of that third component, that third element, which says, is there a systematic, not systemic, systematic exclusion of cognizable groups from the jury veneer? And that's the challenge. So what was, and I realize it's frustrating because maybe there's a lack of information but I think it's the defendant's burden in this case to show a fair cross-section violation. What was Kittitas County doing wrong that contributed, besides systemic problems, but systematic problems of the jury selection procedure that resulted in underrepresentation of people of color in the veneer?
Your Honor, as you mentioned, there isn't a lot of data, so this would be more of speculation on my part, but I would say that given that we have not only both the Superior Court judges having concerns about the lack of diversity, but then the prosecutor also stating that there is concerns, clearly there's a step missing. Either maybe they're not coming in, we can't really say, but that's also the idea that they're just quote unquote not showing up, and there is referencing people of color in this case. That's the same excuse used back in the Jim Crow days.
Although it's also what was said in Rivers. I mean, what Justice Stevens wrote for a unanimous court in Rivers is we're doing a poor job. We don't have juries that are reflective of our community, but we're not finding that the problem is with the way that we're drawing our panels or sending notices out. Maybe we need to increase pay, but that's not fair cross-section problem. That's a policy problem, which is what Rivers wrote about.
Yes, Your Honor, but here I would say that, first of all, this is a smaller community, so just having the two Superior Court judges, there's more interaction just by sheer number. But even if it is more of a policy question, like the River said, as you said, I would say the under RCW 228-150, Superior Court judges are still required to adopt a procedure to fulfill the spirit of the laws. So not only do defendants have the constitutional right to an impartial jury trial, we also have this other RCW that requires this random jury selection process be kept on file for that transparency aspect of it. So we're not even to the point of a procedural issue. To me, it feels more like Kittitas County isn't making sure that everything's transparent, we're following all the rules so that there is no questions about this.
And the yellow light has been on for about a minute. You want to reserve the rest?
I do, thank you,
Okay.
Your Honor.
Uh-huh.
Good morning, Your Honor. May it please the court, Jesse Eldred on behalf of the state of Washington. Judge Stobbs, nice to meet you. Judge Cooney, you as well. Judge Pinnell, I am more awake and more experienced than the last time you told me to take it, but thanks for having me back. Well, I want to begin at the same place I started my brief by acknowledging the reality that systemic racism did play a role in this case, as it does in all cases in Washington, unfortunately, as Justice Stevens recognized in her majority opinion, as you mentioned, a unanimous opinion. However, the Durham factors require evidence of systematic racism. As recently as August 2023 is when the Rivers case came down. This case was pending when that opinion was published. I addressed it in my response brief. I admit I had a little bit of an advantage because it was not in existence when the opening brief was written. But I didn't get a reply in this case. And that's concerning to me that the court had to bring up the Rivers case because I see it as analogous on all fours and totally dispositive of the first issue. We may not, Justice Gonzalez's concurrent opinion makes the case that we may someday have to do better than the Durham factors, but where we stand today in early 2024, the Durham factors control the resolution of fair cross-section claims.
What do you say about the concern that when defense counsel went to the county asking for information for how it was done and kind of got some roadblocks? I think it's hard for defense counsel to be able to meet the Durham factors if the court isn't providing its information.
Sure, that's fair. I think that exchange happened a year before jury trial started, a year before there was actually jury selection. Defense counsel was directed to go to the court administrator. Arguably, it should have been in the clerk's office and not the court administrator's office. At one point, the jury selection administrator was in the courtroom and available for examination. The defense did not take up any opportunity to actually visit the court administrator to cross-examine the jury administrator. For a whole year, the defense did not follow up on their claim that jury selection is systematically racist and discriminatory in Kittitas County.
Are there written procedures in Kittitas County about, okay, this is how we send out notices, this is the Secretary of State's office, driver's license, is there a written policy that the court uses?
Yes, Your Honor. First and foremost, the process of jury selection in Washington is controlled by statute. The Kittitas County does randomly select jurors based on driver's license information or identification card information and voters records. Not one or the other, they're required to do both in order to ensure a fair cross-section comes in. The deputy prosecutor, in his response to the defense, made a point to go check and satisfy himself that yes, we're complying with those requirements. I don't think he put the policy itself as an exhibit. It's the defense's role to make their record to support a fair cross-section claim. They did not do that. I myself am not testifying here. I did go verify, hey, we've got this policy in place somewhere, court administrator, correct? And she found it for me. I said, please make a copy of that and make sure it's at the clerk's office. At any rate, I am satisfied. Yes, we're following that. But again, it's not my burden.
This record. I mean, I think there could be concerns if you were to read it, like what are the weights given to each one? Are there preferences, given to certain neighborhoods? I mean, there could be some real scrutiny given to the plan, depending on the level of specificity, but if it's not in the record, we can't really look at that.
I agree, and it's not, and it's the defense's burden to prove up their fair cross-section claim. They didn't do that. In fact, this morning is the first time I've ever heard the defense actually go through the Dern analysis. They did not do it in their opening brief. They didn't do it in the pleadings in trial. They consistently made this claim as arising under 18 USC section 243 and the 14th Amendment. They avoided the Dern factors and the Dern case strategically, I assume, because either they couldn't or they didn't want to prove up the first cross-section points. And maybe they thought that it's a litigation strategic choice.
Is there another test that could apply? I mean, I understand there's Batson, and once you're in trial, is there another test that applies besides the Dern fair cross-section test?
No, Your Honor, especially not after Rivers, which is why.
Right, well, there's not a separate state test. There's not a separate federal test.
No, unless a litigant wants to try to prove up an equal protection violation, which is what I have understood the defense to be doing, is saying, hey, we're not trying to make a fair cross-section claim, we're making a 14th Amendment claim. I went through the analysis. Then they kind of mixed apples and oranges and said, if we do go through the, they mentioned Dern in crossing or in passing, but did so in a criticizing way, like, hey, Dern has been manipulated and abused by prosecutors, especially. They said, and that's true, and it probably has been. That's why we have GR 37.
So if their argument is that we need to move away from Dern, that's not something we can do given Rivers, correct?
Yeah.
And given Dern.
Well, yeah.
Yeah, well, that's the thing. Rivers says explicitly Dern applies for
Right.
these claims. And
Right, but that's something that this court, we can't do.
Yeah, what would be the separate equal protection analysis? Would you say the elements of an equal protection analysis?
yeah, so that goes back to the, I went through this in my brief extensively. It goes back to the Castle case from 1950, which says that the 14th Amendment federal law protects both criminal defendants and members of the veneer in the population from invidious discrimination. And we're getting away. GR 37, this court recently authored an opinion saying GR 37 protects everybody of all races. The 14th Amendment protects everybody of all races. It protects the jurors that the defense wanted to pass over in favor of that they preferred to see on the panel. It's somewhat insensitive. If Judge Hooper had applied one of the remedies that the defense asked for, as she recognized, she would have been in violation of the statutory mandate that the jury selection be random. She would have been in violation of the 14th Amendment, and that would have sustained a claim under US code for section 1983 claim. I'm glad she didn't do that. And this case really is all about remedies. Rights and remedies go together. That's one of my favorite quotations. And the three specific remedies that the defense asked for are unconstitutional on their face, and there's not enough evidence to support a Dern claim. Does the panel have any more questions about the first issue?
I don't. The second issue wasn't argued, so unless we give more time to appellant, I think we'll submit the second issue on the briefs.
Okay.
Unless the panel has any questions, in which case I'll give more time on the first issue.
I don't.
Or the other issue.
No.
Okay,
Okay,
thank you.
I'm actually gonna sit down then. Thank you,
Okay.
Your Honor.
Thank you.
Thank you, judges.
Ms. Casey?
Okay, so I would like to address the Rivers case again. The big distinction in this case is that we have the two Superior Court judges specifically stating that there will be no people of color on the jury, and that the other judge, Judge Hooper, recognizes that this is a problem.
And why is that other than being an observation? Why?
Because that speaks to the process in the community and the jury selection.
So you're saying that those comments were evidence of systematic exclusion?
Yes, Your Honor, because those are the people in the community who work there. This aren't pro tem judges. They're there every single day
But-
working with the community.
You think that that means it's evidence that Judge Sparks' intent is there will be no people of color on this jury, meaning I'm not gonna allow it happen? That's a significant judicial conduct violation.
Yes, Your Honor, and I can't speak directly to his specific intent behind that. But what I would say is it's probably an observation that he saw being in the community every day. And because of that, that's a bigger concern that the Kittitas County should have the data available to make sure that there are no cross-section challenges, that there are no concerns, but that isn't available. And we have the two judges who work in that community every single day who recognize that is an issue. And there's just nothing being done
But
about
we
it.
have 9 justices on the Supreme Court who also recognize it's an issue.
Yes, Your Honor, and ultimately it should not be up to the defendant to hold may I continue?
Yes, please, and thank you for asking.
It shouldn't be up to the defendant to hold the clerks to the burden of providing a fair trial. Thank you.
Thank you. This case is submitted, and thank you very much, Ms. Casey, for your presentation. You did a very good job, and we appreciate your hard work on this case.
Thank you, Mr. Eldred.
Yes, thank you, Mr. Eldridge, as well. This matter is submitted.
The court disagreed with Mr. Gerald's arguments and affirmed the previous ruling. They stated Mr. Gerald failed to provide evidence there was discrimination affecting the jury pool. There is no evidence the jury selection process was discriminatory or that discrimination affected the jury in his case. Additionally, there was no evidence that the prosecutor's improper comment during closing argument resulted in prejudice that had a substantial likelihood of affecting the jury's verdict. And there you have it. Please like and subscribe to watch more appeals next week.